I'm up late, and I was about to go to sleep, and I realized, no, I better say something here. I'm wanting to cover a very important detail. I just listened to Judge Cashman interact with Don Juan Moses at the trial. I just listened to a series of people, Taylor Cipriano, Sue Blankenship, Kathy Lowell, and Jonathan Tucker on the stand, interviewed by Don Juan Moses. I want to go over all the details tomorrow if I get a chance, or shortly, excuse me, but I want to address something that I don't want to forget. The salient feature of this trial to me right now, and probably always will be, for anybody looking at this trial honestly, is what Don Juan Moses describes to the judge as putting child custody before child safety. There is a point just after Tucker finishes his testimony at 12 o'clock for lunch break, when the judge, just after that finishing of the testimony, advises Moses to steer clear of discussions about domestic violence or the level of child abuse concerns, either way, whether alleged against him or any concerns that he alleges against Jessica and her boyfriend, particularly the boyfriend. She very clearly indicates to him and tells him in no uncertain terms that this trial is not about child abuse or child abuse levels or evidence of child abuse. She says, yes, she makes a concession afterwards saying, yes, there is a portion of the trial that's dealing with that. And she certainly heartily incorporated that theme into her judgment in defining Don Juan Moses as the violent person and completely excluding Jessica from the possibility of being violent, who on the DHHS records is described as the aggressor, repeatedly described as the aggressor in different scenarios, and as described indeed as having a pattern of being pushy, getting into Moses' face about things and causing Moses to have to push her away, which was interpreted gratuitously and ferociously by Judge Cashman as Don Juan Moses manhandling her, turning her hands back on her arms before punching her in the head to cause her to experience a second blow to the head upon contact with a wall and then sliding to the floor. Unbelievable bias on the part of the judge. But the part that I was wanting to focus on very clearly tonight is just that the judge is clearly advising Don Juan Moses, steer clear of any concern about domestic violence, steer clear of any concern about child abuse alleged against you, or that you would be tempted to allege against the boyfriend of Jessica Pinkerton. It is the salient feature of the malignant spirit, defining the malignant spirit of the judge. The malignant indifference of Judge Cashman. Malignant in the sense of plunging children into abuse, careless of their concern, of the concerns of the children, the needs of the children, the agony of the children. Malignant because it's a hateful thing not to care. But what I look at particularly is the literally demonic prejudicial approach of Judge Cashman to this matter, saying this court process is defined for us as being a case that is to be looked at in terms of how the parents interact with each other and how they interact with the children, as the primary basis for what the outcome of this case will be. That was told to Don Juan Moses when he spoke, when he was sat before Magistrate Cadwallader, if that's her name, in the pretrial, who gave him the ground rules, the rules of the game, so to speak. But the problem is that this is Moses versus Pinkerton. This is the case of Moses contesting the concern for a mediation, the interest in a mediation in which equal custody would be offered. It is a case of Moses saying, no, this is a case of child abuse that needs to be dealt with. I am not going to allege that we could both co-parent together justifiably, reasonably, and conscientiously. It cannot be conscientiously done. I will place my children in harm's way to allow them half the time or whatever amount of time to be with their mother under circumstances that have not been corrected by her. Not once, but twice, under two separate perpetrators, and ultimately three. Just before trial, the son of the boyfriend had inflicted an injury to the anus of that child or rectum, such that the child could not sit down. For hours at a time, he was in anguish where he had to stand at times, he had to sit sideways, and he expressed pain by crying out as well. Not once, but numerous times. All of this was presented to the judge, and she still clearly had an interest in focusing on just who can demonstrate that they're parenting the children well in the outward niceties of the regular functions of day-to-day life. Never mind what happens when Jessica's working at night and the boyfriend is the one babysitting the children and inflicts sexual violence upon the 3-year-old autistic girl who doesn't know how to speak, and the then nearly 5-year-old boy who is punched in the genitals every night when he's put to bed. The complete unconcern of the judge regarding the allegation that the child was injured, her irritation and frustration with the fact that a video presenting evidence of a child being abused was the subject of discussion when Sue Blankenship was on the stand, who had reviewed that video and with her supervisor concluded that this matter should be presented back to DHHS as a matter of urgency, and that they were both intending to have it sent back to DHHS. And yet the judge, knowing that this matter of concern of such gravity was presented and that it ended up going back to DHHS, nevertheless, even after that evidence was presented, was determined to treat this matter cavalierly, callously, as simply a matter of who is the best outward parent in terms of the outward day-to-day interaction with the children, not with regard to the concern about whether or not they permit or actually perpetrate abuse. It was a staged trial based on a prejudicial, slanted intention to determine custody of children, not on whether one or both of the parents, one or the other or both parents, were abusive or allowing abuse, but determined on the basis of meeting certain criteria for good parent as determined artificially and outside the context of abuse, prescribed that way by the magistrate and by Judge Cadwallader, by Judge Cashman and Magistrate Cadwallader. The thing that's so absolutely amazing, that is stunningly frightening, is that Judge Cashman was determined to tell Don Juan Moses, look, we are not going to be discussing domestic violence or child abuse. We are going to be focusing on how you interact with your children and how you interact with the other parent as the basis to determine the custody of the children. And Don Juan Moses protested and said, doesn't safety come before custody? That was the eloquent truth. And I had stated on the stand that, of course, we are concerned about how Don Juan interacts with his children, but we're equally concerned and rightly concerned with whether the children are abused. And I was very persistent on the stand, detecting that the judge was indifferent to that, and speaking that, therefore, even more directly. Because I noticed that the judge didn't care. And that is why I pointedly told the judge that the interest in the safety of our children is paramount to the politics of the system. I very clearly indicated, as I did more clearly the following day, that corruption must be dealt with in government and that DHHS can make mistakes. I very eloquently addressed that point, thankfully, for the record, for the American people, before Judge Cashman, who did not wish to engage this matter. I explained to Judge Cashman unequivocally that if there's corruption, we must deal with it, and that the Don Juan Moses case against Jessica Pinkerton, if it is in any way tainted or corrupted by the state to allow a false adjudication of custody for her, it must therefore entertain the evidence of that corruption that obstructs justice and the evidence of the abuse that is perpetrated, that is covered up by the DHHS. If the child's safety is paramount, then you have to go after the details of the corruption, the details of the abuse, the details of cover-up. You cannot isolate good parenting from the abuse setting in which children are plunged by a derelict DHHS working in collusion with a derelict judge. You look at any possible evidence of physical and sexual abuse in conjunction with parenting skills otherwise of the parents and their day-to-day interactions with the children and with each other. Judge Cashman defied constitutional law, the Bill of Rights, the due process of Don Juan Moses, by arbitrarily, cavalierly, disdainfully repudiating any concern about domestic abuse or child abuse, physical and or sexual, in favor of a simple, clear-cut question whether certain check-the-box questions are answered regarding who is the best parent, or should the parents have equal custody. But Magistrate Cadwallader had very vindictively and intimidatingly warned Don Juan Moses that if he was not willing to go roughly equal custody, if not actual equal custody as a proposition made by the DHHS attorney, who tore up his materials, promised to if the materials were not accepted. Very clearly, all of them, the DHHS, the Pine Tree Legal, Jessica Pinkerton, obviously protected by the phalanx of defenders, a chain of command hierarchical system of DHHS, desperate to maintain its image unstained and unsullied by the evidence of corruption. They were willing to propose to Don Juan Moses to have equal custody. Even willing to have the boyfriend removed from the house if Don Juan Moses would simply agree to equal custody. But something told Don Juan Moses, do not compromise. He very clearly, unequivocally, without any reservations, said it's too late, because he had known that Jessica had flouted his concerns, had scorned, had ridiculed his concerns about child abuse. And he'd already seen that with regard to the older child, Mason, with Jessica's uncle the pedophile and how she didn't care, continued to have the child exposed carelessly to that man. And now with the latest revelations that he had addressed it to Jessica, she had poo-pooed them as him just trying to make trouble for her. She even made a scene in the parking lot, according to what he stated at work, right after he had begun to make expressions of concern for the children being abused by the boyfriend. And so the evil incarnate in the person of Judge Cashman, in reflecting exactly what Magistrate Cadwallader stated, that this tribunal has nothing to do with the justice of the Constitution and the Bill of Rights and the due process of citizens that can provide evidence and witnesses demonstrating corruption on the part of the state agency, the DHHS, and other agencies and persons affiliated with it, but can defend but can provide absolute proof of child abuse. These rights were denied by these two judges conspiring to create a tribunal based on an artificial pretext of who is the best parent. And the vindictive, the villainous, the subversive, duplicitous plot to make the verdict be an entire custody for one parent or the other is the retaliation perpetrated by these two judges against Don Juan Moses for saying, I am not going to agree to a mediation of half and half, in which I have to sustain support, to countenance, to enable the child abuse of 1, 2, or 3 children under more than one perpetrator, or under at least one perpetrator. That evil proposition that says, because you didn't agree to equal custody, we're going to crucify you in the judgment, because Judge Cashman very clearly stated that Don Juan Moses was physically violent to Jessica Pinkerton. She stated it as facts and evidence rather than as complete speculation, which is the verdict of DHHS in closing the case against Moses under the advising of Molly Butler Bailey, the attorney, guardian ad litem, who said there is no way to tell who is telling the truth here. And yet Judge Cashman saying this is not a case that is to be closely looking at domestic violence, entertained in the most hideously grotesque manner the histrionic portrayal of Don Juan Moses as getting so close to Jessica that she could taste his breath as he bent her hands back onto her arms, punched her in the head, causing her to strike the wall and slide to the floor. It is a hideous merchandising of children on the part of judges, and nothing less. These judges, or at least Judge Cashman, needs to go to prison. Yes, you heard me correctly. Judge Cashman needs to go to prison for failing to discipline that attorney, for suborning perjury, for failing to recognize the perjuries by Sue Blankenship, Taylor Cipriano, Christine Lynn Ash, for failing to hear the testimony of Kathy Lowell and Jonathan Tucker, to recognize the candor and the clarity, the conviction, to recognize the demeanor and the experience of these parties on the stand. She should go to prison for blocking Don Juan Moses' father from being able to speak, for blocking Tiffany Marshall, Don Juan Moses' cousin, who had evidence of the same child abuse that I shared, that the boy couldn't sit down. He was in such pain in his rear area. as evidence of what was stated to Tiffany Marshall by the boy. That he had been struck in the rectum by the boy at the house. That testimony is further developed at Maine Medical Center, where Don Juan Moses didn't catch the details because it was late at night, or if he did, he didn't tell me about it. But upon hearing the recording sometime later, I recognized that the woman asked the key question: what happened? And the boy said that the older boy at the house, who's the boyfriend's son, wiped me so hard it hurts. And that was the answer we were looking for. And the following day, which he looked for when he went to a hospital in Massachusetts, not realizing that answer had come to him because he was so persecuted by them. The manner in which they treated him, saying, we don't see anything wrong. Even though the recording of a nurse or doctor, not sure, a woman with a foreign accent, I believe, very clearly arriving at the truth that the boy was wiped so hard by the son of the alleged perpetrator that this boy was in pain and even vomiting and not able to eat for at least a day. Judge Cashman could have learned these details at that trial, could have learned all these details except for the transcript information from the hospital, because we didn't discover that until afterwards. Don Juan Moses didn't tell me about that detail, and I didn't listen to the transcript. But what will allow for justice in America? What will allow for justice in America is for people to put all the exhibits together and be able to cover all of them, to have all the witnesses come in and allow all of them to speak. But because Don Juan Moses and Jonathan Tucker did not consider all the details, being overwhelmed with life experience and not being attorneys, never having done this before, even though the telltale evidence was in the recording of Maine Medical Center, in which the boy was described, when the boy was asked what had happened, and the boy very clearly told that the older boy in the house injured him in the rectum. That, in connection with the other evidences of abuse of the children on the video, which Judge Cashman had to review, in which she saw the boy motioning a punching motion on his groin, shows that Judge Cashman had no excuse but to consider that either that was a prejudice statement on the part of that boy, pressured by the father to make it look like he was punched by the boyfriend, or it was the boy describing exactly what was happening. And the judge should leave the benefit of the doubt for child abuse. That is the rule by social services, to give the benefit of the doubt to the possibility of abuse when there's gray area. Neither the DHHS nor Judge Cashman did that. And Judge Cashman, recognizing Sue Blankenship, having turned the case from moderate back to urgent after reviewing that video in which the boy strikes himself in the groin to symbolically, he makes that movement as if he is. That caused Sue Blankenship and her supervisor to send it back to DHHS, although they perjured themselves. She perjured herself by saying that we didn't send it back. It went back to DHHS apart from us. It was their way of properly parsing their statement, properly phrasing things circuitously in order to avoid accountability for what they actually stated. A perjury was stated when she stated that we did not send it back. We did not propose for it to go back to DHHS. It went back apart from us. It was a nuance of expression, a way by which they could, the two of them, only one being interviewed, Sue Blankenship, her supervisor not being there. Sue Blankenship was permitted to commit perjury by Judge Cashman by stating, we didn't send it back to DHHS. It was done outside of our hands. like Pilate washing his hands to seal his fate. They were washing their hands to allow the DHHS to lie. The clear statement that Don Juan Moses didn't catch in court, incidentally, and in the trial process, when he had Sue Blankenship on the stand, he couldn't bring it up, is that when Sue Blankenship denied having referred the case from moderate back up to urgent and sending it back to DHHS with a supervisor, when she denied having done that, saying that it was an action done beyond them and outside them by DHHS to return to an urgent matter, and further perjuring herself and stating that my supervisor and I were under the assumption that you, Don Juan Moses, would go bring this matter the following day to DHHS. That was blatant perjury, and that is why she was so ashen-faced, nervous, even in the hallway when I saw her, and I could only imagine her visage in the courtroom, which her voice clearly evinces, was pallid as she spoke. She went further in her perjury to state not only that they didn't send it back to DHHS, but that it was taken by DHHS. But there's some other detail that I was about to mention, and I lost track of it now. There was another detail resembling her verification of her perjury, besides simply saying that they did not send it back. It was taken over by DHHS. Oh, yeah, that very thing I mentioned. The second part is that and she volunteered this as if to pretend to be ingenuous. Sue Blankenship stated, "It was my impression that you were going to take this matter in hand the following day and take your video and take your case, take your concerns to the DHHS." That is bold perjury. Because in the video, in the recording of Sue Blankenship and her supervisor with Jonathan Tucker and Kathy Lowell on the phone, Don Juan in person with them at the kids' piece near the jetport in Portland, Maine. On that phone, Kathy Lowell and Jonathan Tucker heard what Don Juan Moses heard, and what anybody can hear on the recording. Either Sue Blankenship or her supervisor, or both of them, are heard very clearly and without hesitancy stating, after having viewed the video, we are going to present this as something that should go back to DHHS. We're going to propose that they take this case. And you will not hear from us if they take the case. If you do hear back from us, it means they have refused to take the case back. That's the truth. That's what's stated. Don Juan Moses wasn't on the ball on that point, or didn't remember the details of that in the courtroom to pressure her vis-a-vis those particular details. That would have been very good, but we still caught her committing perjury in behalf not only of her and her organization, but also her supervisor. So there it is. I wasn't planning on covering so much, but I figure while it's fresh in my mind, I'll just take care of it. There it is. We will talk soon again.